I have watched this mechanism before, not in the text of a law, in the architecture beneath it. When you cannot ban the weapon, you restrict what makes it functional. When you cannot eliminate the right, you erode the conditions that make it exercisable. In early 2026, a bill was introduced in the United States Congress under the title Stop Online Ammunition Sales Act of 2026. The legislation did not propose banning firearms. It did not attempt to repeal the Second Amendment. It targeted something more foundational. It targeted the supply chain. And in doing so, it proposed a framework that, if enacted, would make the practical exercise of Second Amendment rights dependent on government permission at every point of acquisition. The bill's provisions are precise. Online ammunition sales would be effectively eliminated. All purchases would require face-to-face transactions at federally licensed dealers. Every buyer would submit to identity verification and background checks identical to those required for firearm purchases. Ammunition dealers operating without a federal license would face criminal penalties. And any single purchase exceeding 1,000 rounds would trigger mandatory reporting to federal and local law enforcement agencies. These are not abstract regulatory adjustments. They are structural changes to how approximately 42% of all ammunition in the United States currently reaches civilian hands. According to industry data compiled by the National Shooting Sports Foundation, online and mail-order ammunition sales represented roughly $12 billion in annual commerce as of 2024. Approximately 68 million Americans purchase ammunition at least once per year. Of those, an estimated 29 million have made at least one online purchase in the previous 12 months. The bill's supporters argue that these provisions close dangerous loopholes. They point to mass shooting incidents where perpetrators purchased thousands of rounds online without triggering any law enforcement attention. The 2012 Aurora theater shooter purchased over 6,000 rounds of ammunition through internet retailers before killing 12 people and injuring 70. The 2017 Las Vegas shooter stockpiled over 45,000 rounds. Online sales, advocates argue, allow individuals to accumulate lethal quantities of ammunition without any of the oversight mechanisms that exist for firearm purchases. These arguments have political resonance, but they do not address the constitutional questions that the bill's structure raises. And those questions, in the legal landscape that Bruen has created, are more consequential than the bill's sponsors appear to have anticipated. The historical tradition test, established in Bruen and reaffirmed unanimously by all 9 justices in 2025, requires that any regulation of Second Amendment rights be consistent with the nation's historical tradition of firearm regulation. The question is not whether a regulation serves a compelling interest. The question is whether there is a founding era or Reconstruction era precedent for the type of restriction being imposed. Applied to ammunition regulation, that test exposes a significant constitutional vulnerability at the core of this legislation. There is no historical tradition of federal licensing requirements for ammunition dealers. In 1791, when the Second Amendment was ratified, ammunition components were available without restriction from any hardware merchant, apothecary, or general store. Black powder was sold openly. Lead shot was cast at home. Paper cartridges were manufactured privately without any licensing requirement or government oversight. The founding generation understood that the right to keep and bear arms was meaningless without access to the materials that made those arms functional. During the Reconstruction period, when the 14th Amendment incorporated Second Amendment protections against state governments, ammunition remained freely accessible. The late 19th century saw the rise of commercial cartridge manufacturing, with companies like Winchester and Remington producing metallic cartridges at scale. Those products were sold through general merchandise catalogs, hardware stores, and mail-order retailers without any licensing framework, background check requirement, or reporting obligation. Sears, Roebuck and Company was selling rifle cartridges through its mail-order catalog by 1897. The commercial infrastructure for ammunition sales existed and operated without federal oversight for over a century. The reporting requirement for purchases exceeding 1,000 rounds raises a different but equally serious constitutional question. The bill would mandate that dealers transmit buyer information to federal databases and notify local law enforcement. This creates a permanent government record of ammunition acquisition by private citizens who have committed no crime and are under no investigation. The Fourth Amendment implications are considerable. The Supreme Court has been steadily narrowing the third-party doctrine that previously allowed government agencies to collect commercial transaction data without warrants. In Carpenter v. United States, decided in 2018, the court held that accessing historical cell phone location data constituted a search requiring a warrant. The reasoning in Carpenter suggested that the collection of detailed records revealing patterns of lawful behavior implicates constitutional protections, even when that data passes through commercial intermediaries. Ammunition purchase records reveal significant information about individuals. They indicate frequency of use, type of firearms owned, quantity of reserves maintained, and purchasing patterns over time. A government database of this information, compiled without warrants and triggered by the simple act of purchasing a legal product in a legal quantity, creates exactly the kind of surveillance infrastructure the court has been scrutinizing more carefully in recent years. The licensing requirement for ammunition dealers introduces a separate layer of constitutional tension. Federal dealer licensing creates government control over who may legally participate in the commerce of a constitutionally protected right. The Bureau of Alcohol, Tobacco, Firearms, and Explosives currently licenses approximately 55,000 firearms dealers. The addition of ammunition dealer licensing would bring an estimated 120,000 additional retailers under federal oversight, including sporting goods stores, hardware stores, farm supply retailers, and online merchants currently operating without any firearms regulatory framework. Licensing regimes give government agencies the authority to deny, revoke, or condition the licenses that enable commerce. If ammunition dealers require federal licenses to operate, the federal government acquires the ability to restrict the supply of ammunition indirectly by restricting who may sell it. A dealer whose license is denied or revoked cannot legally sell ammunition, regardless of whether the denial is justified. The administrative discretion embedded in licensing systems creates leverage that can be exercised without any legislative action. This is a pattern with historical precedent. In the decades following the Gun Control Act of 1968, the ATF used its licensing authority over firearms dealers to reduce the number of licensed dealers from over 280,000 in 1994 to approximately 55,000 by 2024. The reduction occurred not through legislative action, but through administrative enforcement, compliance requirements, and inspection protocols that made small-scale dealing economically unsustainable. The same mechanism applied to ammunition dealers would give federal agencies the ability to reshape the retail ammunition market through administrative pressure rather than public legislation. The face-to-face purchase requirement effectively ends the commercial model that online ammunition retailers have built over 3 decades. Companies like Ammunition Depot, Lucky Gunner, and Sportsman's Guide operate primarily through internet sales. Combined annual revenue for the top 10 online ammunition retailers exceeds $2 billion. Eliminating online sales does not merely inconvenience customers, it destroys entire business categories that exist because internet commerce made ammunition accessible to rural Americans, competitive shooters, hunters in remote areas, and consumers who lack access to well-stocked local retailers. Rural impact is particularly significant. In counties with populations below 25,000, the average distance to a federally licensed firearms dealer exceeds 43 miles according to ATF dealer location data. Many residents in these communities currently purchase ammunition online precisely because local retail options are limited or non-existent. Requiring face-to-face purchases means requiring travel that imposes time and economic costs that urban consumers do not face. The constitutional question this raises is whether a regulation that makes the exercise of Second Amendment rights significantly more burdensome for rural Americans than for urban Americans can be justified under the historical tradition framework. Background checks for ammunition purchases add another compliance layer. The National Instant Criminal Background Check System processed approximately 21 million background checks for firearm purchases in 2023. Adding ammunition checks would exponentially increase that volume. According to FBI estimates provided to congressional staff during preliminary hearings on the bill, the system would require a minimum of 400 million additional checks annually, based on average purchase frequency among the 68 million Americans who buy ammunition each year. The NICS infrastructure does not currently have the capacity to process that volume. Expanding it would require substantial federal investment and would create delay mechanisms that could effectively ration ammunition availability during periods of high demand. These capacity constraints are not incidental, they are structural. When a legal process is made sufficiently burdensome, compliance becomes selective. Wealthy, urban, time-flexible consumers can absorb the delays and travel requirements. Working Americans in rural areas, people with limited transportation, and small business owners who cannot afford extended compliance delays face effective barriers that their constitutional rights nominally prohibit. Second Amendment organizations have already announced legal challenges contingent on the bill's passage. The Firearms Policy Coalition, the Second Amendment Foundation, and the National Rifle Association's Institute for Legislative Action have each issued statements indicating that litigation would be filed within hours of enactment. Their legal theories converge on 2 primary arguments. First, that ammunition regulation is inseparable from the right to bear arms under the historical tradition test. Second, that the reporting and licensing requirements constitute government surveillance of lawful constitutional activity without adequate procedural protections. The historical argument has particular force. If the Second Amendment protects the right to keep and bear arms, and if arms are functionally inoperable without ammunition, then restrictions on ammunition access are restrictions on the right itself. No founding-era precedent exists for requiring background checks, dealer licensing, or government reporting for the purchase of ammunition components. The founding generation purchased powder and shot without any of these mechanisms. That absence of historical precedent, under the standard that now governs Second Amendment analysis, is a fatal constitutional defect. Congressional sponsors of the bill have anticipated these challenges. Their legal memoranda argue that ammunition is not an arm within the meaning of the Second Amendment, and therefore falls outside the historical tradition framework entirely. They cite the text of the Second Amendment, which protects arms, not ammunition, and argue that regulating the supply of ammunition is constitutionally distinct from regulating the possession of firearms. This textual argument has not been tested before the current Supreme Court. But legal scholars following Second Amendment litigation consider it a weak foundation for legislation of this scope. The court's reasoning in Heller established that the Second Amendment protects the core right of self-defense, a right to possess a firearm that cannot be loaded and fired because ammunition is unavailable or inaccessible is not a meaningful right to self-defense. The constitutional protection extends to what makes the right functional, not merely to the physical object in isolation. How the current court applies that reasoning to ammunition regulation remains to be seen, but the trajectory of Second Amendment jurisprudence over the past 2 decades does not favor regulations that make the practical exercise of constitutional rights contingent on government permission at every transactional step. What the Stop Online Ammunition Sales Act of 2026 represents is not primarily a public safety measure. It is a test of the boundary between the Second Amendment right and the regulatory infrastructure that surrounds it. If Congress can require background checks for ammunition without historical precedent, it can require them for cleaning equipment, for storage devices, for any accessory that makes a firearm functional. If Congress can mandate reporting for purchases of 1,000 rounds, it can lower that threshold to 500, to 100, to any number that captures the purchasing patterns of ordinary gun owners. If federal licensing can be imposed on ammunition dealers, the administrative discretion that comes with that licensing can be used to reshape the market in ways no legislation explicitly authorizes. I have seen this before, not as a single law, but as a method. The right remains on paper. The infrastructure that makes it exercisable is quietly placed under administrative control. And when the infrastructure is controlled, the right becomes theoretical, available in principle, contingent in practice. The Stop Online Ammunition Sales Act of 2296 has not passed. Its constitutional fate remains undecided, but the architecture it proposes has been built before, in other contexts, around other rights, and those structures once constructed do not easily come down.